This presentation covers Chapter 6 of Introduction to Paralegal Studies, A Critical Thinking Approach, 5th edition by Currier and Eimermann. Chapter 6 has two parts. The first part involving on the larger topic of civil litigation is its alternatives, and its alternatives are called ADR, which is an acronym for Alternative Dispute Resolution. This covers Chapter 6, Part 1, ADR. Standard warning. Civil litigation and its alternatives. Abraham Lincoln's quote here is very appropriate, because we do in law firms want to discourage litigation, although the stereotypical understanding of a lawyer is one who is in court fighting for client rights, fighting for the outcome of a case in someone's favor or disfavor, as the case may be. Nonetheless, persuading neighbors to compromise whenever you can is the goal of attorneys in most cases. In fact, it's true that litigation in some firms can be a weakness, and is considered a weakness because they would prefer not to be in litigation at all. Chapter 6 has two parts: alternative dispute resolution and civil litigation. An overview, again, we'll be covering in this presentation alternative dispute resolution. Alternative dispute resolution refers to techniques other than full-scale litigation for resolving conflicts. It tends to resolve conflicts more rapidly and at a lesser cost than litigation, and there are two very common forms called arbitration and mediation. In addition to the forms of arbitration, there are also the concept that we're trying to encourage out-of-court settlements, and we're trying to involve a neutral third party like an arbitrator, a mediator, or a private judge, and also know that these can happen, either one of these types of arbitration or alternative dispute resolution, will be happen either before or after beginning litigation. So civil litigation can be prompted by a complaint filed with a court, but alternative dispute resolution is still possible even after that point. And we're going to discuss in the following slides some of these alternatives. There are technically, and as described in your textbook, two types of ADR. Within the umbrella of it, there is the possibility in some cases that the court will refer a case to ADR, meaning alternative dispute resolution. There are also private ADR opportunities that covers everything else. These are not referred to by the court. So the point of these 2 points in this slide is to explain that there are some situations where the case is already in court and the court has referred it to ADR. There are also cases where people avoid court entirely. They never file anything in the court at all, and they hire someone to handle a neutral third party to be the to listen to the case and help determine an outcome. One of the most common forms of ADR is a negotiation. Negotiation is when the agents for the parties involved, these agents are called attorneys, work together and try to resolve the conflict without any form of mediation or arbitration, or either court-related or voluntary private. In other words, negotiation is really where people begin before filing a lawsuit most of the time against another. Picking up the phone, calling the other side, sending a demand letter, Asking them to resolve a conflict is usually a first step that lawyers take. As already noted, there are private and court-related mediation types. So these are forms of ADR that include private or court-related mediation. Arbitration, which we'll talk a little bit more in a couple of slides, and mediation as well. But arbitration can be binding, meaning that the outcome is required, that it must be followed. There are also, in some cases, mini trials. These are where both sides, it's a form of arbitration, it's a form of ADR, where there are high-level executives from both sides, and this would be in a business type of case. So if we had, let's say, just for the sake of understanding, let's say State College of Florida had a contract dispute with Florida Power and Light over their bill, and the high-level executives at State College of Florida and the high-level executives at Florida Power and Light would have a private judge, and they would engage in settlement negotiations with the private judge acting as a neutral third party. Private judging is a hired judge. One of the examples I can think of offhand is Michael Jackson years ago got a divorce from the mother of his children. Can't remember her name sitting here right now, but they had a private judge. It didn't go to court at all. Private judge handled the whole trial of sorts so that there was no public exposure. Other forms of our ADR include early neutral evaluation, which happens very early in the litigation, and an expert, a subject matter expert we call them, here's the position statements of the various sides in the litigation and evaluates the case, and that evaluation is then used to sort of help as think of it as like a consultant's, an expert consultant's suggested outcomes. A summary jury trial, a six-person jury renders a non-binding decision, and these work very much like trials do. They would then go through a trial. Would not be something used for a very large-scale trial. Summary jury trial, they pay each person to be there, so they need to involve things that have a low level of evidence. Summary bench trial, similar to the summary jury trial. However, instead of a six-person jury being used, they have a hired judge again. So arbitration was mentioned in the earlier slide. Two of the most common forms of ADR include arbitration and mediation. And arbitration is where parties submit their disagreement to a neutral third party called an arbitrator. And this person is a decision maker. The arbitrator is not a judge, but acts like a judge. And the parties, before entering arbitration, agree to accept the arbitrator's final outcome. Thus, the arbitrator's decision is a binding decision. Arbitration is common in business. If, for example, you can think of the last contract that you entered into, some excellent examples are an apartment, or your telephone service, a gym membership. One of those, or all of those, probably have a clause in the contract that says we will submit this to binding arbitration, and this forecloses the opportunity to go to court at all with most types of claims against the landlord or the phone service provider or whichever other one I mentioned just now. And it's common in business to do this to, one, save money. They multiple claims that, I mean, there are many, many, many people out there using Verizon phone service, for example. And if all of their clients, their customers, I should say, had a dispute, it would be very expensive to resolve every one of those, extra $100,000, those little bills you get that you wish you didn't. You wish you could sue them for getting you into it. The phone company, that is. That would not normally happen in court because of these contract clauses. And it's common in business because it saves time, it saves money. It also is common because it keeps situations out of the public eye so that the business doesn't suffer as a result of it. So, arbitration, how are they handled? Well, they're much like a trial. All the parties come to the arbitration. They have attorneys to represent them at the arbitration. There's an arbitrator who is like a judge, as mentioned earlier, and there are witnesses. So the people involved are similar to trials. The process at arbitration is much like a trial as well. Each party makes an opening statement. They present evidence. They ask questions. There's cross-examination of witnesses, and they make a closing statement. So it's very much, again, just like the process of a trial. One of the key differences in arbitration versus trial, however, is that in trial there are formal rules of evidence. If, for example, in a trial I have a contract, I would have to either make sure that the people involved stipulate to the authenticity of the contract, and we would have to go through some formal evidentiary processes to bring that contract to the courtroom and use it in the courtroom. So anyway, you have to lay foundation for the contract. You have to prove that it's an authentic contract. If it's a copy, you have to prove it's a copy. All of these evidentiary rules, which we'll discuss, I think, in chapter 16 or 17 of the textbook, will apply in trial that don't apply in arbitration. And this is one of the ways that arbitration goes a little faster and is less expensive. Written submissions. If there isn't a actual trial-like event called arbitration, it is also possible for arbitration to be done in what we call on-paper format. And that means both parties will submit written submissions. It's not appropriate in every case, but the evidence, a paper outlining the evidence, outlining the parties' side of the story would be done on paper, and then the arbitrator would render the decision based on that paper, the paper and the evidence received. And there would never be an opportunity to go to trial or to an arbitration-like event. Mediation, and again, arbitration and mediation are the most common types of alternative dispute resolution. So arbitration is that trial-like event. Mediation, on the other hand, is a different process, and a neutral third party is involved, and this person is called a mediator, and this person will assist the parties reaching the mutually agreeable, and this is one of the key terms, voluntary compromise. Now, many people have the opinion that who've been to mediation do not really feel like it was voluntary, or some people feel that way after mediation. But the point is that mediation, it's not a required event like arbitration, required in respect to there's a binding outcome. It's not compulsory that there be a binding outcome with mediation. And the third party at mediation facilitates the mediation. And we find that mediation is used often in certain areas, but the future relationship, um, but we find that the cases suitable for mediation are those such as family law matters like child custody issues and property division issues. We also find that where there are disputes on damages, that mediation may be a place to go in order to resolve those types of disputes. But again, it's not a binding situation where people must come up with must have an outcome like binding arbitration would have. The benefits should be discussed real quick here too at this point. Mediation is common in family law matters, and it's a way to get people past the problem of trial, that the judge is going to decide what will be the outcome of the case. And instead, in mediation, many studies show that having a personal having a personal involvement in the final outcome, and agreeing to something in mediation is more appropriate in many types of family law cases. The other point is, like I said here, a tort case. A tort is where there's been a wrong between two people. We covered that in another case, in another chapter. Or two or more people. There's a negligence. As an example, we talked about the truck accident at the intersection. And we're not really sure how to quantify the damages that a person has sustained, the plaintiff has sustained in a case. And since we're not really able to quantify that well, going to mediation might be an opportunity to have a facilitator try to help people come up with what you might call the least painful for both sides. An outcome that is the least painful for both sides. Many or some states have mandatory mediation in certain subject areas. The foreclosure crisis has brought about, for example, the Florida Supreme Court Task Force. They've called for mandatory mediation in foreclosure actions, and in fact, there is mandatory mediation in some foreclosure actions. In addition, one of those areas of family law that I talked about a minute ago will also have some mandatory mediation. In Florida, there is a rule that requires mediation in contested child custody matters. And this is, again, an opportunity for the parties to get together with a facilitator and try to facilitate an outcome as far as child custody matters are concerned. Mediation, I explained arbitration is sort of a trial-like event. Mediation, however, is not. Many times mediation happens in a lawyer's office, in the conference room of a lawyer's office. Mediation can happen by Skype. I've known of that to happen with technology advancing. That's going on. And mediation is where both parties are the opportunity. Like I said, mediation happens in law offices a lot of times. There are also the family court mediators. They have an office with conference rooms. In other words, it doesn't happen in a court-like feel of a trial-like type of event. Both parties can still be represented by an attorney with mediation. And a mediation starts out with the initial session where the mediator tells the participants about who they are, what they're doing there, that they play a neutral role, and explains to the parties how the process will proceed. And there in the group, and again, they can have their attorneys represent them there, but there are no objections. I object, Your Honor, that type of thing. It's a lot less formal than a court-like appearance situation. Each party is given an opportunity to explain their view of the situation. Next, The mediator will meet separately with each party and gathers more information. Communicates in interview kind of thing. A caucus is where the mediator says, okay, now I've heard your initial point of view. Now here, you and I sitting here together, tell me more about your situation. Tell me more about your point of view. Why why do you have that point of view? Not so much, what brought on the point of view, but as far as, a child custody issue, for example, explain why you don't think the mother, or if meeting with the mother, why the father should not have anything but supervised custody, for example. And these caucuses are used to draw out more succinct information than the initial session would render, because the people involved don't always in the initial session tell everything they want to say. After those caucuses, where the mediator meets separately, there's a compromise situation where the mediator hears both sides, and now meets individually with each of them to see if what they're willing to do. And this is an example that I think I found in a book or something. The mediator might say to someone, would you be willing to give up, let's say it's a couple arguing about the outcome of their property settlement. So these two people getting a divorce have, houses, or have a home and 5 cars, and we'll say two, a home, 2 cars, and a huge savings account. And maybe the facilitator, the mediator, would say, okay, I've heard your side of the story. Now tell me, would you be willing to give up your share of the marital home, for example, if you were to get, the same amount of money in cash as the value of the home? And that's what the compromise solution period is for, where the mediator is facilitating some thought as to, what if we did this and you did this, sort of a negotiation period with a neutral third party. That's really what it comes down to. This is intended to bring the parties to a collaborative posture, to remove the combat feeling and help the parties collaborate and jointly construct a written agreement. So, and what happens is an agreement, if a mediation works, if the parties do jointly construct a written agreement, it is written down, and that is binding because it's like a contract. The people involved say, okay, we have come up with this outcome, we've signed the papers, it's just like a contract, and the court then would enforce that contract. So it would be like a settlement agreement, but it would be a mediation agreement. Now, a little bit about the mediators. Mediators have to have certain qualifications and training. Training of mediators is going to depend on the state requirements. Florida Rule of Certified and Appointed Mediators, which you can look up online at thefloridabar.org, or if you have a set of the rules printed copy that you can purchase at the school store, you can look at this. Rule 10.100, and I'm looking at the 2014 issue of that rule. The volume of the book says 2014, so that's the year I'm pointing to in my citation. There are county court mediators, family mediators, circuit court mediators, and dependency mediators. And each of these people are required to have certain qualifications. And it's kind of like based on a point system. It depends on which genre, court, county court, family, circuit court, or dependency, how you look to certification. So they're certified, and they have to meet each type of mediator has to meet initial certification criteria. For example, the family mediators, and they are in Rule 10.100, subsection 3C. And that tells me that a family mediator, for initial certification as a mediator, and it must have at least a bachelor's degree and 100 points. And the point system is explained in the Florida rules for certified and court-appointed mediators. And they received those points um, that have to include successful completion of family mediation training program, and the Florida Supreme Court certify or approves, I guess is a better word, the program. So if they go to an approved program, they get an initial 30 points. Then they have to have, if they have education and experience, say for example a person is a family law mediator, family law lawyer, then they would have some initial points that they get for experience. So to meet that 100 points that's required, 30 of it is reached by taking the training, 25 according to the rule is reached through education or mediation experience, and 30 points for mentorship. In other words, people um, that end up certified have to go through a mentorship period. Um, and there are other points received for advanced education. A high school diploma, for example, has a lower point value than a PhD, for example. So there are different types of points or different amounts of points, and their experience is all based on how many hours and in what location they had the hours of mediator experience. You can look these up, and I highly recommend that if you're interested in mediation, that you interview someone who is doing mediation. They will help you to understand what they did to become a mediator, and also tell you the likes and their dislikes about it and what kind of money you might expect as a mediator. Next, or lastly, I should say, I have a little bit of information on what the paralegal's role in ADR is. And it's really important to, if you're going to stay in a paralegal role, that paralegals can be mediators. You draft demand, but you can also, as a paralegal, assist mediators and arbitrators. There's probably a larger role in arbitration as a paralegal working for an arbitrator or a paralegal working for lawyers who are involved in arbitration than there would be in mediation. Some of these areas are listed here. A demand made, you write a demand to another party that says we're demanding arbitration. That would be something a paralegal would be involved in. Researching the rules and regulations for the alternative dispute resolutions. As I pointed out earlier, in arbitration, for example, there are no formal rules. The rules of evidence are more relaxed, but there are rules nonetheless. I'm sorry, but nonetheless there are rules that apply. But they're within a rule book of a private organization that people subscribe to. Drafting agreements, if there's a mediation or if there's an arbitration, and there has to be some signed paperwork, a paralegal helps with drafting those. When selecting an arbitrator or a mediator, there's a need to investigate a little bit about the person, do some background information of the mediators, arbitrators, or judges to see, which one you might be interested in hiring on behalf of the client, and setting up the facilities, arranging for them where there can be an alternative ADR proceeding. A conference room at a large hotel. If you have the need for a lot of witnesses and that kind of thing, more space is needed to facilitate that type of thing. But it's like setting up a courtroom in a different place. So that's the kind of thing a paralegal would work with. In addition, drafting documents involving the outcome of a settlement agreement. So let's say that parties in a divorce have completed, have agreed to something. They might do some property transfer documents or lien releases. Storing and transmittal of documents. Sometimes documents are, when they're generated, a contract or whatever, you have to mail them. You have to send them to maybe the court with a notice if it's court related. assisting in the assisting in preparing questions for the jury if there's a summary jury trial proceeding. Of course, legal research and analysis is a given. That's going to happen no matter what area you're in. Mediation, arbitration, any of the above, all of the above, and as the standard traditional paralegal as well. You have to obviously have an understanding of the substantive field that you are helping with, and also if you decide you want to be a mediator, you would attend mediation training. And as an arbitration paralegal, a lot of information for arbitration gathered as far as evidence, information, research on factual stuff would have to be done. And obviously assisting the attorney at the arbitration proceedings. My experience with mediation is they're typically, if you're working for the mediator, you're really not doing that much other than maybe helping set up a place, but more or less as the mediator's role is a facilitator, and usually the paralegal at that firm of the mediator will actually help draft the final contract if there is a mediation settlement agreement, if there is one at the end generated or resulted in. As an arbitrator's paralegal, an arbitrator being a lawyer that's entering into arbitration for maybe the person who's like a plaintiff or like a defendant, there is a lot more responsibility in that particular role. So that's it. That's the ADR section of Chapter 6, and there'll be another part on civil litigation, part 2 of the Chapter 6. So look for that. If you want some more information about ADR, I recommend, and if you're interested in going into ADR of some kind, I recommend you look at the Florida rules for certified and court-appointed mediators. Look at the qualifications, interview someone who is a mediator and find out more. Look to finding out the costs of taking one of the Florida certified mediator training programs. And if you're interested in working for lawyers who do mediation, maybe contact some of the lawyers and paralegals in that field to talk to them about what they're doing. All right, well, thank you, and we'll move on to the next presentation.